Yeah, I move that the bill now be read a second time. I use the opportunity to I'm pleased to have the opportunity to introduce the Planning and Development Amendment Large-Scale Residential Developments Bill 2021 at second stage in the Dáil here today. And I do wish to thank members for facilitating the debate on this very important bill. We just completed report and final stage in the Seanad earlier this week, and over the course of its passage there, senators were very much engaged with the subject matter of the bill, with lively and constructive and detailed debates in some parts on all of its aspects, and I welcome that. There were a number of amendments made to the bill, which I was happy to accept during the Seanad committee and report stages, and I actually feel that it would enhance the bill, and I'll go through some of those amendments that were made in a little bit more detail later on. As you'll be aware, the Programme for Government Our Shared Future committed to not extending the Strategic Housing Development or SHD planning arrangements which were introduced under the previous government's Rebuilding Ireland Action Plan, and we committed to not extending them beyond their legislative expiry date, which would be the 25th of February next year, 2022. Furthermore, in the recent Housing for All Action Plan was published in September, Action 12.3 commits to the introduction of a new planning process for large-scale residential developments, or LRDs, to replace the previous SHD arrangements. I'm very happy and Oireachtas that this bill delivers on both of these commitments. Primarily, though, and most significantly, I'm very happy that this bill delivers on a commitment that I have made and this government have made to restore decision-making to our local authorities. And it's something that I've always believed in, and I have always believed is a much more appropriate place for decisions to be taken. Underpinning that, though, is also reinstating the primacy of local area and local development plans, and that's very evident in this bill. And we're restoring planning to a local level, and the provisions contained in the bill will also restore the two-stage planning process for large-scale developments, with decision-making for such proposals returning to the local planning authority in the first instance, with a possibility of a subsequent appeal to An Bord Pleanála. In addition to the benefits of returning the primary decision-making function for LRDs to the local level, the reintroduction of an appeal mechanism to the board should assist in reducing the number of judicial review challenges against LRD planning decisions, contrary to the SHD arrangements, where the only appeal mechanism under them was actually to seek a judicial review to the High Court. And I do think on the passage of this bill, and that's why there's an urgency about it, that the sooner we transition into decisions being made at a local level and restoring the two-level planning process is crucially important. And that's why, like to hear that we do need to have this bill concluded within the next 10 days or so, this can take over from the 17th of December. Anyway, and I know I should have said in the Seanad, as well, that this bill was passed unanimously without dissent, and good debates from all sides of the House, both opposition and government. Just on the main contents of the bill, if I may, following the Seanad discussions, it now contains 18 sections, which I'll now turn to in a little bit more detail. The primary provisions contained in a limited number of sections, namely sections 3, 8 and 17, with the supporting provisions for these arrangements contained in the other sections. Rather than go through every single section individually, I'll instead outline the key elements of the provisions of the bill. Happy, obviously, to take any questions that we can move forward to next stages. The proposed new arrangements retain some of the positive elements of SHD, namely, which was the mandatory pre-application consultation of proposed developments between the developer and the planning authority to tease out issues prior to the submission of a planning application, as well as mandatory decision timelines, thereby providing greater certainty in terms of planning timelines. They are mandatory and they will be brought into this bill. The new arrangements will comprise 3 stages: pre-application consultation, planning application stage, and where required, an appeal stage which will go to An Bord Pleanála. Turning first to the pre-application consultation stage, which is primarily detailed in section 3 of the bill, it will involve 2 steps. Firstly, an initial more informal pre-application consultation on the proposals between the developer and the planning authority, as already mandated under Section 247 of the Planning Act for projects of this scale. This will then be followed by a formal request for an LRD meeting by the developer requiring the submission of a fairly detailed initial documentation in relation to the proposed development. Planning authorities will be required to hold such LRD meetings within 4 weeks of the receipt of the meeting request, and then issue an LRD opinion on the proposals within 4 weeks of that LRD meeting. So an 8-week process for that pre-application stage, and a maximum of 8 weeks. The LRD opinion issued by the planning authority will set out whether the documentation submitted by the developer constitutes a reasonable basis for moving to the next stage in the process by way of submitting a planning application. It will identify any issues that need to be addressed when subsequently submitting that planning application. Drawing from the SHD arrangements, this new Lrd pre-application consultation is intended to improve the quality of planning applications subsequently submitted after the pre-application process in respect of large-scale housing developments, and reduce the need for further information requests in respect of subsequently submitted planning applications. Second stage of the LRD process is the planning application stage. The new LRD arrangements will rely on existing Section 34 planning application process and will require planning authorities to determine the LRD planning application within 8 weeks of receipt of the application, with, as indicated, limited scope for further information requests, which should be limited anyway because of a more detailed pre-application process, the details of which will be set out in supplementary regulations. Further information requests have in the past resulted in considerable delays in determining planning applications. However, the new LRD arrangements are intended to front-load the consideration of a range of issues at the pre-application stage, as I said, thereby reducing the need for requesting further information at planning application stage and thereby streamlining the decision-making process. With regard to the third stage of the process, the appeal stage, and that's provided for in Section 7 of the bill, the board will be required to determine LRD appeals within a mandatory 16 weeks of receipt of the appeal. Again, there will be similar limited scope for further information requests. The mandatory timelines for the 3 stages of the LRD planning process, which have the potential to be almost as time efficient as the SHD arrangements they're replacing, will streamline the overall decision-making process, thereby providing greater clarity and certainty with regard to timelines. To help ensure adherence, and these are mandatory timelines, a penalty payable to the developer will apply to both the planning authority, which will be 3.5 times the application fee, or €10,000, whichever is lesser, and the board, €10,000 for late decisions on LRD planning applications or LRD appeals. I should also mention one important difference from the outgoing SHD arrangements, which is that the new LRD will allow up to 30% of the gross floor space of the proposed development to be commercial or other use, instead of the 15% cap that was in place under SHD. This change actually acknowledges that such developments, particularly in our cities and our inner-city brownfield sites, tend to require a greater mix of residential, commercial and other use in order to take into account the differing needs of inner-city areas, and that's up to 30%, as well as they'll make the LRDs in such inner urban areas more economically viable. In line with the principle of compact growth, more residential development is required in urban areas, and this change in the scope of the arrangements is intended to facilitate greater development of brownfield sites in those inner urban areas that might otherwise be the case. I think all of us want to see more development, compact growth within our cities, particularly on brownfield sites, and this bill will assist that. The bill also proposes a number of transitional arrangements in relation to the expiry of SHD and their replacement by the new LRD. There are 2 scenarios which I'm going to address under the transitional arrangement. Firstly, developers with projects already in the SHD system and who've received an opinion on their proposals from the board on the commencement of the Act will have 16 weeks from the commencement date to submit their application to the board. Secondly, developers who've commenced the SHD process by requesting pre-application consultations with the board and are awaiting an opinion on their proposals on the commencement of the Act, they will have 16 weeks to submit an SHD application to the Board from the date of receipt of the pre-application consultation opinion from the Board. In both scenarios, the Board will then have a further 16 weeks to make a determination. These are fairly standard transitional arrangements which will apply and generally apply when changing from one planning system to another. However, it's important to note that for large housing development proposals that have not commenced the SHD process on the date of the commencement of this Act, and with the cooperation of this House, I intend that to be the 17th of December next month, any such future development proposals for large housing developments will be required to go through the new LRD process. Consequently, it is intended that this 17th of December date will effectively mark the transition date from SHD to LRD arrangements. A further provision in Section 6 of the Bill will be subject to some discussion and was subject to some discussion in the Seanad. This section amends 50A of the Planning and Development Act 2000 to provide that any party to a judicial review challenge may apply to have a High Court judgment referred directly to the Supreme Court, bypassing the Court of Appeal. As I mentioned in the Seanad, there is good rationale for this streamlining provision, which, once introduced, will have the effect of reducing significantly the time for disposal of litigation and enable relevant projects to proceed earlier than otherwise would have been the case. Just to, if I could, summarise some of the amendments that I took in the Seanad. There was an extensive debate on a number of aspects of the new streamlined planning procedures. Amendments were proposed and discussed on all sides, and they resulted in my acceptance of a number of key amendments to the pre-application stage of the LRD process, which is contained, as I mentioned, in Section 3 of the Bill during the Seanad committee and report stages. These are now incorporated in the Bill before us today, and I think the Bill is improved as a result of it. I'll briefly outline which amendments I took on board. Firstly, some concerns were expressed regarding the making available of documentation at the planning application stage relating to the previous LRD meeting or LRD opinion stages. And in light of the discussions in the Seanad, the Bill now includes a provision whereby the planning authority shall keep a written record of any third-party consultations that are held prior to the LRD meeting and attach a copy of such a record with any subsequent planning application. Furthermore, the Bill now provides that the LRD opinion issued to the developer at the end of the pre-application consultation stage shall be made public when the LRD application is made. Secondly, there was some concern in relation to the omission of the obligation that a developer should provide a statement at the pre-application consultation stage as to how the proposed LRD has had regard to the local area plan and/or the development plan. And I'd originally intended to provide this by way of regulations, but we had a good debate on the matter. And again, I think it reinforces what we're doing here is putting the development plan and local area plans, recognising their, and rightly, their primacy, that I was in a position to accept revised wording on this amendment at report stage. These enhancements to the provisions reflect that we're trying to achieve here, or what we're trying to achieve, excuse me, which is that restoring a streamlined two-stage planning process for large-scale housing developments while also facilitating open, transparent and meaningful participation by the public in the overall process. I also brought forward an amendment at Seanad committee stage to provide that the housing strategy prepared by the local authority shall take into account the need to ensure that home ownership as a tenure type is provided for and estimated in its housing strategy. This provision, and this is a significant provision, because it provides for the first time in planning law that home ownership shall be recognised and factored as a specific tenure type in drawing up of local authority housing strategies. Another commitment that we've made in our Housing for All plan, and a very important step towards putting home ownership back in the reach of thousands of people, and affordable home ownership in particular. So we've underpinned that, used this bill as an opportunity to do it. So for the first time in planning law, home ownership is recognised as a form of housing tenure. Just to conclude, Caherly, I think you'd agree that this bill contains a number of fundamental and important legislative features. Again, restoring the two-stage planning process for large-scale residential developments, with the primary decision-making returned to the local planning authorities in the first instance, thereby, and rightly so, enhancing local democracy. We're enhancing public participation in the local decision-making process, with members of the public now having two opportunities to input into the process, at planning stage and at appeal stage. And then we're retaining an element that was positive within the SHD arrangements, the mandatory pre-application consultation, and also the statutory and mandatory decision-making timelines to provide certainty. All of these are aimed at facilitating speedier decision-making in the planning system for much-needed housing supply. Because whilst we want to improve our planning and improve the access that people have and the input that the public have into planning applications, we have to look at the context of where why and when we're bringing this bill in the middle of a housing crisis. Because we need to streamline our planning process too, to deliver homes for our people. And I really believe that the increase in levels of JORs through the SHD process has been because people felt that they did not have a say at the early part of the process. And I believe in local democracy, and I believe in local public input into the planning process, and this government does too. And that's why these changes are very significant, and why I want to ensure that they're in place from the 17th of December. I do look forward to the contributions from all deputies in discussing and debating this today, and as I've said to you, I took on board suggestions and amendments in the Shannon. I'm very open to listening. We'll have committee stage next week on this as well. So I Caherly would like to thank members for their attention today. I hope I've just outlined in brief the main provisions of this bill, which I do believe are very significant. This does herald the end of the SHD planning process, and we're ending it early and earlier than was provided for. I look forward to the debate here at second stage, and also indeed as we move through to committee and report stage next week.